Welcome to Self-Represented in Family Court, the only podcast you need if you're feeling lost, stuck, or overwhelmed in family court. At Self-Represented, we don't waste time discussing the law like all the other podcasts. We focus on what really matters in your divorce or custody case. That's strategy. With your host, Tracey B, former family law attorney turned pro se family court strategist.
So I'm back for a new episode, and it's a new year. It's Tracey B, your host of Self-Represented in Family Court. So I wanted to talk to you about what a lot of people think is a surefire way to quote-unquote win their divorce or custody case. And that is having a lawyer they think is the equivalent of having a strategy. And that's just not the case. So this week, I want to take some time and explain to you why having a lawyer does not necessarily mean you have a strategy. Actually, oftentimes, it means the opposite. So let's dig right in. You all know by now that you absolutely need a strategy. Successful businesses are successful because they come up with a strategic plan, whether that means doing the SWOT analysis or just having an expert come in and assessing things to determine what the weaknesses are, the strengths are, where the opportunities are, the threats, which is actually SWOT analysis, but sometimes they just don't refer to it as that. Either way, most successful businesses at some point, actually regularly, do create a strategy. They create a strategy, they execute the strategy, they adjust the strategy whenever they feel the need to re-examine what's happening in their business. They're professionals who help people create, implement, and execute strategy in their personal life. A lot of life coaches, that's exactly what they do. So why not have a strategy for your family court case? Whether you are self-represented or lawyer represented, you need a game plan. That's what a strategy is. It's a game plan. And oftentimes, quite often, too often, lawyers do not take the time to create this game plan. Let me tell you why. I'm going to give you 5 reasons why lawyers often bypass, overlook, minimize, neglect, ignore the importance of having a strategy, having a solid game plan from the onset of your case. One of the main reasons is because they just don't think it's important. They don't. 95% of family court cases actually wind up settling. Yeah, that's a huge number. So you can have the most high conflict divorce or custody case and just convinced that your case is actually going to go to trial because you've tried mediation, you've tried negotiations, you've tried everything you can think of, and the other party's just not budging, or their lawyer. And so you are 110% sure your case will not settle at any point. You are going to trial. Even in those cases, some of them wind up settling. It can be actually at opening statements. Cases settle at opening statements a lot, even in family court. So a lot of lawyers just don't feel the need to create. And when I say strategy, when I say a game plan, I mean something tangible, something written, something that you're going to be able to refer to from the beginning, from filing to finding, something that you could use as a frame of reference to ensure that your case maintains some continuity, stays on course, and doesn't drag out unnecessarily long. So that's what I mean by a strategy, a game plan. A lot of lawyers don't feel the need to do that because a lot of them are anticipating some sort of resolution before trial. They equate having a strategy with having a trial strategy. They think that you only need a game plan when your case is going to trial. And I beg to differ. I believe that in any area of your life, it helps to have something concrete, a roadmap, a plan, whether it's jotted on a piece of paper or something you type out on your computer, something you journal about. You should have something, especially when you're aspiring to achieve a specific goals or objectives in your life. Having something tangible, cohesive, well thought out, and well planned will help you. It will increase your chances. Studies show that this will increase your chances of succeeding at whatever it is you're setting out to do. And your divorce or custody case is no different. So that's the main reason. Another reason is because lawyers just don't know. They just don't know, that having a strategy is the thing to do. They don't give it much thought. I don't hear lawyers talk about strategy a lot. Even if they do, it's not until somebody brings it up. I don't hear that. That's not a conversation that comes up, especially very early on in the case. And don't get me wrong, I do understand that very early on in the case, it's hard to nail down what's happening or to come up with a comprehensive game plan, but you should definitely have some sort of bare bones skeleton version of it from the very beginning of your case, lawyer or not. And then another reason is a lot of times lawyers just don't want you to hold them accountable. They don't want the transparency because they're finagling, they're winging it, they're just holding on by a prayer. And so last part was a joke. And so, but they really don't want the expectations of you having something happening that may not happen if they actually put it in writing or put it in a solid game plan. Another reason is, I hate to be honest about this, but a lot of times if they give you something solid, then it sort of make how much they can actually charge or earn from your case from a monetary standpoint sort of finite. If they leave this idea of an amorphous strategy or an amorphous game plan, it kind of sort of leaves the door open for more billing, more invoicing. And no affront to lawyers. I did this all. I'm speaking from personal experience. I did all of these things. And there are some lawyers who mean well and they do well and they're very good and they're very honest and they're very transparent. But for the most part, a lot of them aren't. A lot of them just, and it's not with nefarious intent. That's just the nature of the beast. So yeah, that's another reason. And then one other last reason that I can think of is it's just something it's not in alignment with what lawyers do. Creating a game plan, a strategy, that sounds something like, hey, that's not what I want. They equate having a strategy with having a trial strategy. But having a strategy early on is extremely helpful. But a lot of lawyers, that's just not in their job description. They just want to go to court, argue cases, write motions, appear at hearings, and that's it. And they don't want to actually take the time out, because if you do it correctly, it can be quite time consuming, but very helpful. So if you are represented by an attorney and you want a strategy, you want one done, you want them to do one, just ask them, hey, especially from the first moment you meet with them and you're considering hiring them before you sign. You should always ask questions before you sign any agreements and turn over any funds. Ask them, what is their strategy? What is their strategy? Not trial strategy, because if your case doesn't go to trial, then you don't need a trial strategy. Ask them what their strategy is. And again, it can be something open-ended. It should be something open-ended because, as we know, things change in family court by the second. Every second there is something new happening. Every minute, every hour, every day, there is something significantly important, moderately important, and then sometimes just unimportant. But there's always something happening that's going to impact your case in some shape, form, or fashion. So sometimes it is hard to really hone in and pinpoint exactly what the specific items are going to be in your case to create a strategy or to create that roadmap that I'm talking about. But for the most part, any lawyer that's been practicing family law for several years, they pretty much get an idea. And all cases are different, but they're all the same. right? We know that every case has some nuances up from other cases, even the ones that are almost identical. There's still going to be something that sets it apart from the mundane. But on the other hand, there's so many same issues that we deal with over and over again that we can anticipate what the other party's next move is going to be. And that helps, whether it be the other party's next move or a key player in the case's next move. There's always a way to anticipate, hypothesize, or theorize what the next move is going to be or what's going to happen in court. The lawyer can actually create a roadmap, a case map, a game plan based on their experience, their knowledge of the key players, their just identification and observation of things that, are happening along the way. It's not really that hard to come up with a bare bones or skeleton form of a roadmap for your case. And so if you are thinking about working with a lawyer or working with a lawyer, I suggest you ask them about that very early on. And if they attempt to tell you, hey, I never really done that, I don't think it's important right now, why don't you do it? You can do it on your own. You can just ask them some specific questions about the judge, the opposing counsel, the process, the law, the procedure. You can ask them that, and you can take that data, you can take that intel that they provide you, and you can create your own roadmap with my help, of course, because if the lawyer's not going to do it, you and I can do it. We can do that together. That's something that I've been doing since I started working with Pro Se 5 years ago. I've been creating what I call my case map for my clients since 2020. And so I'm well versed at it. What I've been doing is taking information that my client provided for me, information that I've researched, information from observing maybe court appearances from the specific judge or the attorneys involved or any other key players involved, speaking to other people, whatever it takes. My objective is to find out as much as I can from every angle. So if your case is a high conflict custody case, maybe relocation is involved or maybe some DV is involved, then I'm going to take the time to find out what the judge's position is on relocation. If the guardian ad litem gets involved, what the guardian ad litem procedure is and how they actually facilitate doing their investigation for relocation cases or DV cases. I'm going to find out if custody evaluators are going to get involved, who the custody evaluators typically are that are assigned in your specific jurisdiction, and how they move forward. I'm going to do some research on prior decisions. I'm going to do a whole lot of things to come up with that case map. So if you could get some intel, and it always helps to have a conversation with the attorney to find out what they know about the jurisdiction that you're in, about how they operate, the lawyers, the key players, whomever else is the opposing counsel, whomever else is involved in your case. It really helps to know what the lawyer knows so that we can plug that data into the case map. I have a template that I use for my case map that I actually present to my clients, and it ranges. It ranges from a light version all the way up to an advanced version, depending on what it is they ask of me. But you will have a solid roadmap slash case map slash game plan slash strategy working with me. So if the lawyer is refusing to do, that's fine. They're not a bad lawyer because they're not doing it. As I mentioned, a lot of lawyers don't even think to do that until it's time for trial. But I just wanted to really focus on the fact that lawyers are not necessarily going to think of creating a strategy or giving you something tangible to refer to throughout the course of your case. And it doesn't mean that, again, that they're bad, but it might mean that you are exposed, that you may be a little vulnerable because, as I mentioned, having a solid strategy, having a game plan very early on, the earlier on, the better, is going to increase your chances of reaching your goals and your objectives. And no matter what those objectives are, no matter what obstacles or challenges you have to deal with, no matter what the biases or the injustices are, no matter what the things that you're having to come up against as you move forward in your case, having that game plan, having something solid where you anticipate all of these things, where you actually factor in and incorporate all of these things in, it's going to really help you. So I wouldn't beat my lawyer over the head with begging them to come up with a case map of their own. If they don't want to do it, if they give you some reason why they can't do it or shouldn't do it, then it doesn't stop you from taking responsibility of your own case and doing it yourself with my help, of course. That is my area of specialty. I've been doing that for years. I've had people accomplish some great things with having that. It created, if nothing else, they had a lot more awareness of what's going on in their case. They can identify the bottlenecks that was causing delay or causing overwhelm or causing agita in their cases. It's been able to save people thousands of dollars because they were able to minimize the unnecessary delays and the unnecessary stalling of certain parts of their case. I've had people actually able to settle their cases because of it, because they were able to identify what the real issues were, and they were able to basically make more informed decisions about what they should and should not settle with and what they should actually pursue and let go. So no matter where you are in your case, but especially if you are in a high conflict divorce or custody case where there is issues with respect to custody, property dissolution, marital assets, debts, whatever it is, if you feel like your case is somewhere in the cosmos and you have no idea what's going on, you have no idea what the lawyer is doing, you have no idea what the judge is talking about, you're clueless about the process, you are overwhelmed by the legalese, whatever it is, if you are feeling any of that, having that solid game plan, lawyer or not, is going to help you. Again, the lawyer can help you by just answering questions. I will give you a list of specific questions you can ask the lawyer, and I do this all the time. When I work with clients who have lawyers, I just ask them to ask the lawyer specific questions, and when they give that information, they give it to me. We just plug it into my template, and I create this case map for them. That is usually somewhere between 8 and 10 pages, depending on the complexity of the issues involved and the number of issues involved. Sometimes the light version might be 2 to 4 pages, but either way, if you are the kind of person that likes to have something tangible that you can refer to, that you could lean on, that would give you some direction, some clarity, some insight, some wisdom, even some confidence, let the lawyer know that this is something you are insisting on doing yourself or with me. You can let them know. I don't give legal advice because I can't give legal advice if you're not my client, you're not my lawful or my legal client. And if you have an attorney, I can't give legal advice anyway because you have an attorney. So my case back is not a legal advice device or template or tool. It's a tool that's going to help you actually get some clarity on the process, on the aspects of your case that have nothing to do with law. As you know, if you don't, I'm telling you now, family court is 80% strategy, 20% law/procedures. And so that 80% is something that you cannot neglect, lawyer or not. If you have a lawyer, use the lawyer, utilize the lawyer, and use the information they give you to help you create your case map. And if they are okay with doing that or creating their own, then you can take that and rely on that, or you could take what they give you, and again, we can actually work on that together. Either way, having a lawyer does not automatically mean you have a strategy. Please don't ever think that having a lawyer is one surefire way to achieve your goals or your mission. I can't tell you the number of people that I've spoken to or worked with that have had representation and they got more help, more insight, more wisdom from working with me than working with the most high-priced lawyer that they had representing them. So again, no affront to lawyers. No, I'm a lawyer myself. No disrespect. I'm not actually trying to discourage anybody from working with lawyers. I'm just saying that don't rest all of your confidence on having a lawyer thinking that you have a shoo-in with quote unquote winning your case in family court. That's all I have for you today. Hopefully this was helpful. If you are interested in working with me on your own case map, we could do that one of two ways. We could do that on an hourly basis in a strategy session, which are really helpful. We meet for an hour, but behind the scenes, I create a case map light that you can use at any point in your case. And then after that, we can work together on a 4, 12, or 24-week basis where I create a much more in-depth case map for you. We actually work together on executing that case map, even changing it, tailoring it, but mainly implementing and executing it. So feel free to check the show notes for the link to my strategy sessions. They are 1 hour. We meet for 1 hour, but I actually spend about another hour or two behind the scenes working on it. So feel free to schedule one. You will find it extremely, incredibly helpful. And there's nothing else out there like it. There's absolutely nothing else out there like it. So take advantage. Anyway, thank you so much for tuning in. I appreciate each and every one of you. Until next time. Bye.
If you're having an active family court case and something already feels off, you need to identify where your case is seriously exposed. Schedule a strategy session now so we can shield your case from more damage. You can't afford to keep guessing. It's costing you way too much.